confession can be perceived as very straightforward, where confession is inadmissible if the accused did not act voluntarily due to police coercion. As established in R against Sharp 1988, it is unlikely that an accused would confess to any crime which he had not committed, that it was safe to rely upon the truth of what he said. In talking about the admissibility of confession, it must be made voluntary and it should be adhered to the rules of admissibility. In Lemonade against Public Prosecutor 1965, the court made a ruling that a mixed statement can still be admitted as a confession if taken as a whole, if it supports the inference that the accused committed the offense. And in talking about the classification of confession, there are two, which are plenary and non-plenary, as established in the case of Liang Wenheng against Public Prosecutor 2014, where the court laid out the essence that all admissions are not confession, but all confessions are admission as the court set forth in its judgment. In discussing the confession made to a police officer, the confession will be admissible under Section 21 of the Evidence Act 1950, which will be read together with Section 17, Subsection 2 of the Evidence Act, as well as other provisions such as Criminal Procedure Act, CPC, and Dangerous Drug Act, DDA 1952. This was established in R against Wong Ah King, where all confessions were made relevant and can be proved against the maker unless it is excluded by sections in the Evidence Act. Moving on to the next slide, I will discuss on the definition of police officer and what constitutes as a police custody. For the police officer, they will be regarded as a person in authority since they are someone who engaged in the arrest, detention, examination, or prosecution of the accused, prescribed under Section 24 of the Evidence Act, and also established in the case of Diokinan against R 1969. As to what constitutes as police custody, reference can be made to Collins Dictionary, as they will someone who will kept secure under the supervisions of police officers. In R against Leicester 1895, the court ruled that the confession was made irrelevant because the accused was still in the police custody, disregarding the temporary absence of the policeman. In Sambu against Rack 1947, it was held that the accused statement to the police officer was improperly admitted contrary to Section 26 of the Act, as the confession was made in custody. The gist of police custody from these two cases is that it is sufficient if the police are capable of curtailing the liberty of the person concerned. In conclusion, the confession must be made voluntary and the element of oppression should not influence the confession.
Now, Section 25 stated that any confession made to the police officer under the rank of inspector is not admissible before the court. It is clear that for a confession to be admissible, it must be made to a police officer with the higher rank of inspector, with the rank higher than the inspector. Now, in order to render the confession admissible, it must be evidence to show that the officer to whom the confession was made was not below the rank of inspector. This was decided in the case of Li Yameng against PP in the year 1972. Now, in order to define whether it was made to the rank higher or below the rank of inspector, we must be able to define what is police officer. In the case of R and Wong Akin in the year 1935, this case stated that when ordinance says police officer, it must mean police officer. It cannot extend to an act or exercising powers analogous to a police officer. And in the case of Chia Biao-Huat against PP, a customs officer is not a police officer within the meaning of Section 25 of the Evidence Ordinance. Custody of police not to be proved against the accused unless made in the immediate presence of a session court judge or magistrate. This section concerned with a confession made by anyone to a third person while he is in the custody of a police officer, and it is not necessarily made to a police officer. The main condition here is that it is being made under the police custody, be it to the police officer of all rank or to a third person. And what is the meaning of police custody? Now, in brief, Saka on Evidence stated that a man might be held in custody without being legally arrested if he is unable to go where he wants. Now, for the next issue is that where in the case the accused confession is genuinely not admissible before the court under Section 25, yet the accused attorney fails to oppose to admissibility, and what will happen? In the case of Pakim and PP, it was stated that inadmissible evidence does not become admissible by reason of the failure of counsel to object, and appellate court must disregard all such evidence. Thus, if the counsel accused failed to object to such admissible evidence under Section 26, it does not make the inadmissible evidence become admissible. And for the last element is the immediate presence of a session court judge or magistrate. Under the section itself, it does not explain in what manner the immediate presence of a session court judge or magistrate can be done, and under it shall be defined on or be decided on the case-to-case basis. This section, it works as an exception to Section 24, 25, and 26 of the Evidence Act 1950. Section 27 stated that when any fact is deposed as discovered in consequence of information received from a person accused of any offence in the custody of a police officer, so much of the information, whether the information amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved. Now, the basic rule or the general rule under this section is that any statement made by a person while in police custody is admissible as long as it strictly complies with the standards set forth in this section, regardless of whether it amounts to a confession or not. The rationale of this section is it will assist in making a self-incriminatory statement admissible if it can be correctly viewed as knowledge relating distinctly to a reality uncovered as a result of the statement. In the Pulukuri Kotayas case, the court stated that the section appears to be predicted on the belief that if a fact is discovered as a result of the information provided, some assurance is provided that the information is accurate and so can be securely offered as evidence. However, it must be noted that there are few conditions under Section 37 that must be complied with. The first one is that the information must have been received from a person accused of an offence. Such person must have been in the custody of a police officer. A fact must have been deposed to as having been discovered in consequence of such information. And lastly, the information relates distinctly to the fact thereby discovered may be proved.
4. It rejects the admissibility of the confession in a criminal proceeding which appear to be the result of inducement or threat. This principle was derived from the case of Dadu and State of Maharashtra, in which the Supreme Court observed that if a confession to police were allowed as proof in evidence, the police would torture the accused and force him to confess to a crime which he might have not committed. Next, in Section 25, it provided that no confession made to a police officer shall be proved as against a person accused of any offence. The Apex Court opined that the purpose of restriction imposed under Section 25 is to protect the person accused of a crime from third-degree treatment and to also ensure a proper investigation of the crime can be made to bring the real culprit to the judgment. And this was supported by the case of Queen Empress and Babu Lal, in which it observed that the objective rule is to prevent the practice of torture and oppression by police officers for the purpose of extorting confession and securing conviction. An exception to this section can be found under the draft of Kerala of Organised Crime Act, According to this piece of legislation, a confession made before a police officer with a higher level than of a superintendent police will be considered as evidence against the individual who made the confession. Therefore, it can be seen that under this section, a confession made to a police officer is not admissible in the eye of the law and cannot be proved against the person who made that. So moving on to the section 26, it stated that no confession made by any person while he is in the custody of police officer, unless it be made in the immediate presence of a magistrate, shall be proved as against such person. Section 26 is based upon the same fear that the police will torture the accused and force him to confess either to the police officer himself. However, this section recognizes one exception, which is if the confession takes place in the police custody but in immediate presence of magistrate, it will be considered valid and admissible. The rationale behind this is that the presence of a magistrate rules out the possibility of torture, thereby making the confession voluntary. Lastly, in Section 27 of the Indian Evidence Act, it stated that if the accused make a confession, it may be utilized to prove a fact or uncover additional facts during the investigation. There are also relationships between Section 27 and Section 25 of the Indian Evidence Act. In Section 27, it discards the part of the confession which is self-incriminatory and only takes into account the part which leads to the discovery of new facts. However, the court said otherwise in the case of Pakala, Narayana, and Emperor. Section 27 does not allow the admissibility of statement made to a police officer in an investigation.
Relevant provision in this subtopic is Section 76, subsection 2, paragraph A of Police Criminal Evidence Act 1984. It stated that confession must not have been gained via operation in order to be acceptable. Torture, cruel or humiliating treatment, and the use or threat of violence are all examples of operation, as in accordance to Section 76, subsection 8 of PACA. In general, the notions of operations appear to apply only when someone has authority, power, or influence over the accused or person in authority. Next, the operation must be intentional. Finally, it should be stressed that every intentional immorality amounts to operations. Next, under Section 76, subsection 2, paragraph B, it highlighted the reliability test. Under this test, there is a question of whether whatever was said or done during the confession was likely to have rendered such confession unreliable. So by applying Section 76, subsection 2, paragraph B, a trial judge must examine all the relevant circumstances of the interrogations before and after what was said or done, and consider the nature and effect of what was said or done, the seriousness of the offence in question, and the terms of the confession, which may throw light on the facts concerning the interrogations. The prosecution also must demonstrate that the confession was not acquired as a result of anything said or done by someone in authority. In DPP against Pinglin 1976, the police officer stated that if you show the court that you helped the police track down bigger drug dealers, I'm sure he'll keep that in mind when he punish you. The accused revealed the identity of his source, and the House of Lords ruled that the accused's testimony was voluntary since no threat or enticement was made before he confessed. Lastly, the relevant provision is Section 78, subsection 1 of the Police Criminal Evidence Act 1984. So the basic point of Section 78, subsection 1 is that if confessions are obtained unlawfully or incorrectly, they may be dismissed as evidence in the court. For example, in the case of R against Paris, in this case, the accused made a series of confessions throughout the 13-hour interrogations session that amounted to a full confession of his culpability in the case. When he testified before the jury, he stated that he knew nothing about the case and that during the questionings, the police officer just made up answers to their own questions and invented the admission that he was purported to have made. He had refused to sign the interview notes. The court determined that the evidence would be used unjustly and hence omitted it. That's all.
On the similarities and also differences in regards to the confession law between Malaysia, India, and also the UK. The first similarity is that there is a presumption of police in their line of duty would become prejudiced and abuses their power in violating the rights of the accused in order to obtain their confessions. Hence, such provision exists to prevent practice of torture, extortion, and oppression. Second, Section 25 of the Indian Evidence Act, Section 76 and 78 of the Police and Criminal Evidence Act, and also Section 25 of the Malaysian Evidence Act have a set of rigid prerequisites that needs to be fulfilled for confessions to be accepted as legitimate evidence. And final similarities is that both Section 25 of the Indian Evidence Act and Malaysian Evidence Act accepts the admissibility of confessions made in police custody, provided that there is an immediate presence of a magistrate or a session court judge. Now, on to the differences between these three jurisdictions. In the UK, it stresses out the importance of voluntary confessions, regardless of whether it is done in police custody or not. What is important is the reliability of the confession. While in India and Malaysia, the law stresses out that the confession made while in police custody or to a police is inadmissible. However, although Section 25 of both the Evidence Act of Malaysia and India is quite similar, the differences is that in the Malaysian jurisdiction, it specifies that only a confession made to a police officer of a specific rank can be admitted as evidence, while in the Indian jurisdiction, it prohibits the admissibility of confession made to any police officer of any rank. Hence, these are our recommendations. First, amend Section 25 of the Evidence Act following the approach of the Indian Evidence Act. Second, police officer disclosing that a confession as a material factor in mitigating to the accused. And the third one, amend Section 24 of the Evidence Act to include the term oppression. And final one, expand the confession law to Sarawak.